A massive data breach. Ouch. Employees claim that hackers got into the employer's database of personal information, 62,000 employee records, and then used those records to file fraudulent tax returns. The employees claim there was no proper encryption, no adequate firewalls, and no adequate authentication protocol. This is Dittman versus UPMC out of the Pennsylvania Supreme Court on November 21. So the court says, look, the employer had a duty to exercise reasonable care because the employer took affirmative action to store this data and created a risk of data breach. And the intervening act of cyber criminals was within the scope of the risk that the employer created. So we've got liability. But then the court had to look at what's called, oh, this is so old, the economic loss doctrine, which, if you follow that doctrine, bars a negligence claim if it leads only to economic loss without any physical injury or any property damage. This court said, not so, no bar, when there's a legal duty that's independent of any contract obligation. Now, the plaintiffs are still going to have to prove their facts, but if they do, it's going to be expensive. So until next week, keep on doing good work.